House is in committee. Kia ora tātou no reira te whare inga iwi, inga rio, inga hawe wha tēnā koutou, tēnā koutou katoa. Good afternoon, honourable members. We are in committee. Oh, thank you, Mr. Miller. We are in committee for further consideration of the Legal Assistance Amendment Bill, for consideration of the State Sector and Public Finance Reform Bill, the Plumbers, Gas Fitters and Drain Layers Amendment Bill, and the Taxation, Livestock Valuation, Assets Expenditure and Remedial Matters Bill, for further consideration of the Airports, Cost Recovery for Processing of International Travellers Bill, and for consideration of the Administration of Community Sentences and Orders Bill, the Reserve Bank Bill of New Zealand, Covered Bonds Amendment Bill and the Medicines Amendment Bill. Members, we've moved first to the Legal Assistance Amendment Bill, and when the committee was last considering this bill, we had reached part 2, and it's my understanding that the Honourable Leanne Dalzell had the call, and she has 4 minutes 55 seconds remaining if she so wishes. So we do certainly have a significant number of bills here to consider in committee. Point of order, the Honourable Member
Mr. Chair,
Robertson.
I just want to clarify, had we begun the debate on part 2 of the bill at the last point at which this had gone, or were we just ending part 1? I just want to get a clarification of that matter. And I'm just going to continue talking for a little moment longer, Mr. Chair, and see, yes. So were we on part 1 or part 2?
We were, Mr. Robertson. I have it in front of me that we had here, and I have it written down here. Part 2 read, the Honourable Member Leanne Dalzell was speaking at 21:50, the previous, and 21:55. And therefore she has 4 minutes and 55 seconds remaining if she so wishes. The question is,
Mr.
did part 2 stand part? I call the Honourable Leanne Dalzell.
Mr. Chairman, because of the time that has elapsed since we last spoke on this bill, I am going to start again, which is actually quite useful because I cannot remember what I've already said. So it's probably a good thing to start again. So part 2 actually deals with amendments to other acts, and so quite often when you get to the amendments to other acts, you're really just seriously looking at sort of subsequent amendments to what is dealt with in the substantive part of the bill that we've already addressed. However, there are a number of areas that I think it is worth traversing, and that in particular relate to the Care of Children Act 2004. And this is where a lot of the controversy has arisen in terms of some of the changes that have been brought into place. And it isn't clear in terms of the legislation exactly what all of the implications of some of these amendments might in fact be, because I seem to recall from the hearings that we had at the Select Committee, there was a lot of discussion about whether parties would be required to reimburse for the costs associated with Counsel for the Child. I'm looking to the opposition spokesperson on justice for some assistance here, but I think that there was a lot of debate around contribution to the costs for a lawyer for the child, potentially able to be ordered, which would be split between the two parents. And they could be in different proportions, and that was of some concern, I think, because there was certainly a fear that any payments that were required to be made in relation to the legal aid coverage or the payments for lawyer acting for child, then this could actually make people feel quite uncomfortable about their role in the hearing itself. And I must say that there is a degree of disquiet around this particular change. So each party must pay an equal share of the prescribed proportion. So no, the law. I know that we did have a discussion in another bill, which is perhaps not relevant to having a conversation about the Legal Assistance Amendment Bill, but the Family Court Proceedings Bill, there was a deep concern about it because, of course, some may qualify for legal legal aid and others may not. So you've got, you know, one of the parents up for a substantial proportion of the cost and the other parent up for a funded share. And that, I think, created, again, some sense of disquiet about whether that would make the dealings between the parties more or less comfortable and probably more uncomfortable as a result. So there are some significant issues with respect to that. There are also issues around enforcement of orders to refund fees and expenses of court-appointed lawyers. And there's a whole process to be gone through in the legislation to order a refund as a debt due to the Crown by that party and being enforceable in a district court or the High Court as the case may require. And, you know, again, this is, again, forcing people into a situation, well, in relation to the enforcement of a debt, to see themselves in a position where perhaps they're not seeing that their contribution is necessarily their legal responsibility. But it all really comes back to that same issue that we were debating before in the other legislation. And that is that essentially when you've got a government who thinks that family disputes between couples are private matters and therefore not eligible for any form of state assistance, and that the only interest that the government has is in helping parents helping parents agree to their care of their children arrangements. It does seem to be a real mismatch because, of course, the whole focus is actually on reducing costs. So this makes absolute sense when you tie it in with the Family Court Proceedings Bill, but it doesn't make sense when you're actually looking at what might actually be in the best interests of children. And when people are facing these enormous costs, what they end up doing is entering into agreements that may in fact not be in the best interest of their child. And I'll give you one example that came up in one of the hearings that we had where a couple had agreed that they were going to share care, they were going to share the day-to-day arrangements for the care of their child, and as a result of them reaching this agreement that was going to be 1 week about, so 1 week for one parent, 1 week for the other. The child, remind me again, our spokesperson on justice, Mr Chairman.
I call the Honourable Leanne Dalzell.
I think the child was 18 months old. 6 months old. So the child, the parents thought they were doing the right thing. Yes, I know. The point that I'm making is that it's relevant when it comes to cost-sharing arrangements, because a lot of people enter into these arrangements because of the costs associated with them. So there are 3 sets of costs that are now in play. One is the cost of now going to a family dispute resolution, which of course is the other bill. The other is the cost of the child support, because eligibility for child support is dependent on the number of days or the number of hours, essentially, for the primary caregiver. And that has created an incentive for people to look for ways to either share the arrangements so that they're basically, it's like an insurance knock-for-knock arrangements where you can cancel each other out. But then on other occasions they're not able to achieve that. And so none of the costs that the non-custodial parent, or the one providing day-to-day care, the non-custodial parent, that parent isn't allowed to take into account the cost of holding an extra bedroom open, which is an issue for people, especially who are renting. They're not allowed to take into account the extra costs for food and entertainment and things like that for that time. So they continue to pay their child support every week. So the point that I'm making is that all of these issues come into the decision-making process, got nothing to do with the best interests of the children. And then the final one that we've decided to add to the whole mix is that you can pay for counsel for child as well. Well, we've already heard from our debate on the other legislation that there are some limitations around that, and they may in fact, that lawyer for the child, acting for the child and the best interests of the child, may in fact be the only legal advice that anyone gets at any point in time, and it's at the point that they get to family dispute resolution. And so, and now we're going to send them the bill as well to both parties. parties. I actually think that people should take a serious look at what this Parliament does from time to time, and we should join the dots. I mean, we've had an issue down in Christchurch around building consents where we've got a silo mentality within the council, and we've got a silo mentality outside the council in all the different government departments. Even with the Canterbury Earthquake Recovery Authority in play, there are still all these silos all doing their own thing and not joining the dots. Well, for goodness sake, when we're talking about the best interests of children, shouldn't we be joining the dots? Isn't that probably the most important thing that we could do for those little dots? Yeah, I mean, I think that it's absolutely... well, I think it's irresponsible to go through a process of decision-making on these separate issues and silos and not see that they have a huge impact on children. And that's why the word sustainability went out of the title of this bill. It's now the Legal Assistance Amendment Bill. The word sustainability has gone because actually it's not a sustainable proposition. I know that the government took it out because they didn't really want people to focus on the fact that there was only about the money, but actually it's gone for another good reason, and that is that this is not a sustainable approach. If we really care about the best interests of children and ensure that they are at the heart of all decision making, then we wouldn't be doing child support separately from legal assistance, separately from family court proceedings. And I actually know that there are a number of people who agree with that point of view, and I know that there are many actually on the other side of the House who secretly agree with that point of view too and would like to see something done about it. Mr Chairman, the other part of this particular bill talks about the costs of court-appointed barrister or solicitor. So when the court finally reaches the nightmare situation of having two self-represented litigants in front of them who are both going hammer and tongs at each other, finally brings in a court-appointed barrister or solicitor to help sort the mess out, which is going to happen much more often as a result of the previous legislation that we've been dealing with. We're going to end up in the situation where the party's going to be required to pay for that barrister or solicitor as well, even though it's appointed to represent the interests of the court. And I think that there's been a fundamental flaw in the thinking here. You know, early legal advice is what actually helps resolve disputes.
I call the Honourable Minister Chester Burrows.